mineral rights. And I just want to introduce myself. I'm Leslie Serletic. I'm the communications coordinator for Aquila. And Tom Quigley is our CEO and president. He has a master's in geology with an emphasis in biology. And also, master's in biology with an emphasis in botany. And he has a master's in geology, excuse me. And Bob just walked in. He's our senior geologist with a master's in geology. And Robin Quigley is the accountant for the Back 40 project. So with that, we will have an question and answer session at the end of the presentation. However, Mr. Tinti did say if you had questions that he could answer during the presentation, he'd be happy to talk with you about those. So we'll introduce Steve Tinti.
I like to talk with my hands. It's part of my heritage, and I guess I want to talk a little bit tonight about mineral issues. And I think that in doing that, we're going to cover a lot of ground, which is going to have some specific information on certain areas that will give some people some ideas, some understandings, maybe a little bit of insight into the issues so they can make informed decisions about what they do. As an attorney, I always give a nice disclaimer up front, and the disclaimer is we'll talk about a lot of general things this evening, but when there's a specific issue, there could be specific facts and certain law that applies that you really should seek out good advice from an individual that knows the topic. I'm a real estate attorney. I also do governmental law, and I've been in Crystal Falls for about 25 years. And I like a little history, and I take questions from the audience as we go along. Just understand when you raise your hand, you might volunteer for something else. And I need 2 volunteers tonight, and it's simple volunteers. And the first gentleman I met tonight was Tom, I believe. And I'm wondering, Tom, if you would be happy tonight to represent a landowner.
Absolutely.
And your statement tonight is going to be, when I call upon you initially, is going to be, please prove it to me. Sound like a fair statement to start?
Absolutely.
Can I have another volunteer other than Tom for this evening? Do I have to call on somebody?
Yeah.
And your name is, sir?
Paul, of course.
Tom and Paul. Okay. Paul is going to be a mineral owner. And he's going to be the individual that interacts with Tom. And we're going to have a little discussion about it. But first, we're going to digress a little bit into history. Anybody remember anything important that happened in 1066? No. Come on. In England, anybody can think about it. Well, we're getting closer, but one particular event that happened in England in 1066. Maybe I'm the only one that read that part of Pardon?
Our mineral laws are based on those laws that were formed at that time.
Okay, but in 1066, William the Conqueror from France beat Harold in the Battle of Hastings. And the reason this is important is because in Normandy they had a concept called you own estates in land. You've probably heard that phrase before, and you say, what do you mean we own estates? I've got a deed, I own the property, I get a tax bill, the assessor and the local unit of government says I own it. What's this estate stuff? Well, William the Conqueror from Normandy brought in a concept that you split up ownership interests in land to something called estates. And you need to look at that because that has a huge impact as to where we go in this particular state. Another phrase that sometimes you will hear is you will hear people talk about when you own a piece of property, you have a bundle of rights to the property. For instance, the right to use the surface, the air, the water, if you own the subsurface, the minerals. Those are all types of rights that have been created under the law. And in this state, we continue to create those rights. Anybody who bothered to study the law on April 1st of 1997 would realize the Michigan legislature made a new property right called divisional rights, that being the ability to subdivide land without going through the platting process. So this concept goes along. And I've been down here in the last 4 or 5 years a couple times, and I've had a chance to talk to several people over the years, and there seems to be some confusion on how we create mineral rights in this state. And I'm going to read from what is called a title standard, which is basically a compilation by a particular body of the State Bar of Michigan that talks about how you create a mineral right. Real simple. A mineral interest can be created by grant or reservation. A mineral interest may be an entire mineral interest in the real estate or an undivided interest in the real estate. What's a grant? Does anybody know what a grant is? Have I put everybody to sleep already?
Something that's given to you.
Okay, Tom likes me. I'm his next door neighbor. Tom signs a deed to me and he grants to me an interest in his real property. That is a grant, generally a deed. It can be a type of a document, so that's a grant. Now, a reservation in creating is going to be the example. Tom sells me his 40 and he reserves the right to all of the mineral estate, or the right to have a well, or the right to have an easement across it to get to his next property. Very simple. They're basically created by documents. We do not create mineral interests in this state by any other method. You can't go down to the courthouse and you can't file and you can't create one. All of that is a misunderstanding. They're created by what is out there as to things that are going on. Now, at common law, which is our judge-made law, before the legislature started to get involved and add things, basically said, if Tom owns his property, he owns to the center of the earth under him, to the heavens. That was the concept. Real simple, real straightforward. Well, the problem is after the Norman Conquest in 1066, England had some things that started to happen. Some of the things that started to happen, like coal, tin, various minerals they had to start to mine, and with this concept that you can divide ownership of land up to estates, they started to say, let's create a mineral estate. And that's what it is. Now, how many people have had a chance to look at any documents that talk about how you reserve or how you transfer mineral interests? Anybody in this room familiar? Anybody ever read their deed? I assume a few of you did. Any of you find any language on there that says anything about minerals?
Not usually.
Not usually. Okay, why do you think that's true?
Somebody else owns?
Well, let's think of it better. Has there been any real mining history in Menominee County? No. Now, if you were to go up the river, so to speak, to Dickinson County, part of Delta County, iron ore was very prevalent. And if you keep going up, you would find Iron County, you get into Marquette, Ontonagon, all of those areas were mining areas.
Don't forget Quigley.
Thank you. We can add Keweenaw, we can add Baraga, but I mean, this is a problem or an issue that comes up in areas where historical mining occurred. Because that's the only reason that in the example of Tom selling the property that he would have reserved the minerals. If there was nothing there, Tom would have said, I'm not reserving this, convey the property to me. And so, I mean, that's the concept that we have. Anybody believe that minerals generally include limestone, sand, gravel, clay, and water?
Yeah.
Why not? Anybody have any ideas why they shouldn't be?
I thought my brothers had gravel on his.
Okay. Generally, those items are not considered minerals per se. And we're going to talk about some exceptions because those items are generally quarried and they consume the surface as part of their extraction. And traditionally, they have not been considered minerals. Now, we have to start talking about the state of Michigan because prior to 1964, if you didn't pay your taxes to the state of Michigan, you had the state, when they sold the property back to the general public, they reserved mineral rights. And the state defined minerals to include sand, gravel, clay, and non-metallic minerals. So the state of Michigan in tax deeds took the phrase mineral, defined it different, and made that language. Now, Gogebic County, in 1963, a landowner not that much different from Tom, said to Keweenaw Land Association, you don't have the right to come in here and take this gravel and take my surface estate. And it went to the Michigan Supreme Court. The Michigan Supreme Court said, with the language that was employed, that severed the mineral estate, talked of ores and metallic items, and therefore did not include activities that consumed the surface, like sand, gravel, clay, marl, limestone, said it didn't apply. And the case is Fisher versus Keweenaw Land. And that's important because it points out a simple concept. When Tom sold me his minerals, in the example, I have a right, depending on the document that Tom gave to me, on what I can do. And some of the documents you will see language that will read as follows. Reserving to the grantors all minerals. Tom's attorney did that. He needs to get a new attorney. It still works. You could see language that says reserving unto the grantor its successors and assigns all ores, metals, and minerals that may now be owned by the grantor, including without limitation oil, gas, and all other minerals of every kind, nature, or description, together with the right to explore, mine, and remove such minerals, and the rights of ingress and egress from the lands for such purpose. Tom's attorney on that reservation did a better job. Now, that was this much on the page. I'm showing you the bottom of the page, which is a standard reservation that you will see in any type of grantor that's sophisticated. And the grantor will talk about ores and minerals, haloid salts. It'll talk about geothermal steam, sand, gravel, stone. It'll talk about all of those things with development rights. But then it'll go on and say the right to lateral and adjacent support also is going to be reserved. And if I cause the surface to collapse or have to use it, I have the right to buy it back at the then fair market value or the value of its improvements at that time. That is a better mineral reservation if you're trying to protect the mineral estate. Now, every one of these things that Tom and I talked in our dialogues, because I transferred my mineral rights to this gentleman here who volunteered. And I'm sorry, I forgot your name. Paul. And Paul is going to knock on Tom's door and say, I own the mineral rights to this. And what is Tom's response going to be? We're in mixed company, and the answer is, prove it to me.
That's exactly right.
I want to make sure we keep that straight. Okay. How do you prove it? How do you prove who owns land?
Title search.
Title search. Okay. What records are being searched?
You go to the courthouse, neighbor page. And
Okay.
figure out who owns what.
How many of you are comfortable doing that and really know what they're doing? Notice I qualified that. Okay. Anybody know what a patent is?
Yes.
What's a patent?
It's the transfer of land from the U.S. government to the state.
To the state or?
Well, in the cases I've looked at, it's to the state of Michigan.
Okay. Or it can be to an individual. Like if you go down to the Register of Deeds, you'll see United States. Abraham Lincoln signed to, I'll say, Tom, your great-great-great-grandfather, assuming it was in the family. That is what you'll see. It's basically a transfer from the government to a private party. Now in Menominee County, you have an easy task because I grew up in Dickinson County in Norway. And if I go down to the Register of Deeds, I get confused real easy because the old deeds say I'm in Marquette County and say I'm in Menominee County. and you start to wonder what's going on unless you know a little bit of history. If you, actually it will also say you were part of Iron County too, because remember our county's boundaries changed over time, so your register of deeds will have documents in many counties that will refer to property in other counties that aren't the one you're looking in, but it actually is yours. So in Tom's example that we have, he has a patent that went to his great-great-great-grandfather from Abraham Lincoln. And Abraham Lincoln didn't sign it, some other clerk did it, and they just signed his name. So let's keep that. And so Tom has that, and from his great-great-great-grandfather, he died without a will, and it had to go through probate, and it went to his great-great-grandfather, and there's a document recorded at the Register of Deeds. So if you look on his particular parcel, you have the U.S. government to great-great-great-grandfather, to probate estate to his great-grandfather, and then we'll assume that there are deeds and links that go along the equation. Okay? But see, what happened is Tom's great-grandfather got in some hard times in the early 30s, and it reverted to the state of Michigan for tax sale. And the state ultimately kept the minerals, but his great-grandfather bought the property back without the minerals. And that is where our gentleman here has a lease from the state of Michigan. And from Tom's great-grandfather, it went to his father, to him. So if you look at the Register of Deeds in that example, you will find from the government, through a line, minerals to the state, real estate follows through. And that deed will be out there, and it'll be pursuant to Public Acts of 1897, if I've got the correct year that they will have it, 1897 or 1893, it's one of the 2 years. And that severance occurred there. And remember I talked about how we create minerals, by grant or by reservation. And that's an example of a reservation where this gentleman ended up. So if he were to be knocking at Tom's door and says, I have acquired a lease from the state of Michigan for minerals, and you will see notices every year in the paper advertising for leases, that's how he would prove that he has the right to go and utilize the mineral estate on Tom's property. Tom's probably not real happy with it, but assuming the records show that, that's what we're stuck with, because as soon as we started to break up that property into different rights, we created property rights that are protected by law, and you cannot take them by governmental action without just compensation. So as soon as we allowed the creation of mineral estates, we created those types of problems. Now, if anybody has any questions, stop me. Now remember I said we needed to be careful. We need to look at what the document said in Tom's example on how the minerals were reserved. Okay? And in this case that we just used as an example, it reverted for taxes. The state as the owner said we reserve them back. And they used the broad form of the state definition because it occurred before 1964, where sand, gravel, clay, marl, there's another one in there I keep forgetting, non-metallic minerals are included. Now let's change that fact pattern a little bit. And I'm picking on Tom tonight. Tom, you're the first one to talk to me, so you volunteered tonight.
I'm sure it won't be the first time.
Okay, that's good. And I can take it in return too. But I guess the example I want to change, and I have that Tom's grandfather sold the minerals to somebody. And he sold the minerals, and he defined it as ores and mineral rights or interests of record, and that's all he did. He didn't do anything more. This gentleman here, he runs the largest gravel crushing operation in the Upper Peninsula. And Tom has got this nice esker full of sand and gravel that he really wants to get at. He says, I own it. What do you think the answer is, Tom, to that equation?
It depends on when he filed, or that was I guess, registered at the courthouse.
Deeds of record,
Yes,
and we won't get into the 40 and 20 years yet.
okay.
And you only had ores and minerals sold. There's gravel, an ore, and a mineral.
No.
So you tell them, prove it to me. And you get right back into the Fisher versus Keweenaw case, Keweenaw land of 1963, and it says, normally activities that consume the surface do not fit within the reservation unless the reservation says so. So if we use the language that says, together with the ability to remove lateral and adjacent support, to collapse the surface, to use the surface, all of those nice things, this gentleman wins if it says gravel. It has to say gravel. So now I'm going to complicate things a little bit more in this equation.
Can I ask a question?
Go ahead.
Prior to, for generic reservations prior to 1964, is it your opinion that that does include gravel in those other non-metallics?
Only on state of Michigan tax reverted land.
Okay.
Okay, and I would bet if you were to draw a checkerboard of Menominee County and look at how many of them have reverted to the state on tax reversions from the late 1890s to 1964, you would be shocked to see the scope of it. So that's a rule, because generally a mineral does not include sand and gravel. And I'm talking in general terms, so you have to say it. And that's what our Fisher court in 63 said. Because see, if I'm the landowner, if Tom and I own that parcel together, I'm a little upset when this gentleman wants to come and make a quarry, because he's going to remove all the surface, he's going to remove the trees, the vegetation, and what am I going to have left when it's all done? A hole in the ability to pay taxes. Okay, now Tom, new example. Tom reserved the mineral rights, and he employed a good attorney, and he has great language. And I'm the tax assessor. And assuming Tom is not in development, or in the processing or milling of minerals in this state, can I send Tom a tax bill? All he owns is the minerals. Can I do it?
No.
Anybody else have a different answer? Anybody remember Joe Mack from the western half of the Upper Peninsula?
Joe real well.
Pardon?
I knew Joe real well.
Okay. I used to have those trademark black, almost horn-rimmed glasses. And Joe Mack, if the vote was 37-1 in the state senate, you knew who the one was. It was Joe Mack. Well, when he ran for office in 1966, he ran on a platform, we're going to tax mining companies. Strike that. We're going to tax mineral holders. And we're going to have a statute passed that says, if you sever the minerals, we're going to presume every one of those acres that are severed are valued at $5 per acre. It's actually the statute. So let's say the 40. 5 times 40 yields $200. Did I do my math right? Well, we all know, because we're only able to tax at 1/2 of the true cash value, that means it's $100. So what do you think your SEV rate on $100 of value is going to yield for me, the assessor, on these severed minerals? It's not going to cover the cost of the postage. It's not going to cover the cost of the process. And more importantly, how are we going to figure out what nobody tracked because there was no value to it, because this was a non-mining area for all of these years? How are we going to figure that out for me to assess? It's just not going to happen. But the law allows the separate taxation of severed minerals for metallic interests, and I've got to qualify that. And there's a couple exceptions, because Joe Mack also stuck in a couple exceptions that basically says if you're in certain type of mineral development, you won't have to pay it. Some counties started to tax minerals in the late 70s, early 80s and got out of it because number one, they couldn't figure out who owned them. Because if you're in a mining area, it was very difficult. Like I've looked at an abstract in the last 2 weeks for a 40 that was in Iron County, Michigan, near mining property. It's 650 entries thick. It has unbelievable amounts of entry. Down here, some of the abstracts I've looked at are between 6 and 15 entries. Clean as a whistle. It really goes to show what is out there. So I guess I'm pointing these things out because remember when I started we talked only create a severed mineral interest by grant or reservation. Okay? Now how many people have heard this topic about file this claim of interest or go down and file my affidavit at the Register of Deeds and I somehow get minerals? I see a few nods. I won't ask who's done it because I'll be kind. Anybody know what that comes from?
I read it in the paper. Go.
Okay. Which paper? The Globe? The Inquirer? Or we can always give the answer we read it on the internet. And we know everything on the internet is true. End of World War II. The Michigan legislature decided in 1945 that we had now been in a state for about 110 years. That there were too many references to these old things. Like 1834, Bob Smith reserved the following right across this property, okay, for cattle. It's in downtown Detroit. There hasn't been a cattle scene in that area in a few decades. And what was happening is people were saying, this is clouding title and creating problems that when that person comes to sell that land or comes to borrow against that land, that they have this problem that goes back and we need to solve it. So our Michigan legislative solution was, we adopt a statute called the Marketable Record Title Act. Nice complicated act. They put it in place and they said it's going to go in effect in 60 days. Well, the legislature thought that was kind of a radical system, so they extended the window period for 3 years. So in 1948 it went into effect. And in 1948, when it went into effect, it basically adopted a system that said, if an instrument is not reference of record for more than 40 years, and certain other conditions, which I won't get into right now, are not present, we will be able to functionally ignore those old items. Sounds great. Sounds like a great statute. Didn't mention a word of minerals. Didn't mention anything. 1948, that statute was adopted. Really, it has not been constitutionally challenged in a significant fashion to date, though there has been, somewhere in the Appalachia, the U.S. Supreme Court upheld a similar statute with similar consequences. So the consensus is the act will be on a direct attack constitutionally. And so it doesn't say a word about minerals. So Tom's example is, but see, Tom's deed that he got from his grandfather said, because grandfather had a bad attorney, said, subject to all easements, exceptions, or mineral rights and development rights thereto in his deed. Tom got his deed 35 years ago. There's a link recorded at the Register of Deeds, his deed from his great-grandfather in my example, and it's only 35 years. Tom's deed references back to the old one. This gentleman here who acquired the mineral rights from the previous historical example, the act doesn't apply. Now, 40 years sounds like once you have 40 years it works. No, you really have to have 40 or more years without a reference, and you really need to look at that, because I see titles every week where in 1910 Mary Smith reserved minerals. 1923, 1962, references to Mary Jones. You think it could be the right person? Same person? Very well. You know, at one time it was prevalent that when women married, their last names changed. So you need to look at it. The same thing happens with companies. You know, A.O. Smith, or the one that was very popular in Iron County where I practice principally now, it was Jasby Goodman, Sawyer Goodman, Goodman and Sons. All of these variations were out there, so you really need to start to look at all of those names. So if we were using, Tom talked about looking at the Register of Deeds, the records, and I believe this gentleman also talked about it, we look for what the chain of title is, every single link. And if we start from patent to a person, to a person, to a person, if it's perfect, the links line up and there's not an issue. I will tell you that there's a lot of property that is less than perfect. I'm in the process right now of suing 79 defendants to quiet title to a 5-acre piece of property that is worth, if we're lucky, 10 grand. It's that goofed up. It's so goofed up, the tax department is billing for 150% of ownership. Nice racket, wouldn't you think? It's just that much of a nightmare. But you look for every one of those links, so you got to know what you're doing at the Register of Deeds office. Does anybody know Paul Tasanovich? Anybody ever hear the name?
Oh, yes.
Okay. What do you know of him?
Well, he's a legislature.
Okay, right answer. Anybody know of Ken Smith out of Houghton, Michigan? He runs a title company called Copper Range Abstracted Title. He's kind of a character. He's part of the color of Houghton County if you ever go up there. And I say that with good humor intended. Paul Tasanovich was a state representative, and Ken Smith got tired of looking at all of these mineral interests back 100 years and all of these references. So Paul Tasanovich introduced a piece of legislation that became effective in 1997 that amended the Michigan Marketable Record Title Act. And it said, we will include mineral interests, but please listen to how they defined mineral again. Did not include oil, gas. We don't have that problem in the Upper Peninsula. Sand, big issue. Gravel, limestone, not so much in this part, more the eastern end of the Upper Peninsula, clay and marble. Yes?
Well, that's what, Public Act 154 of 1997? And
I can't tell you if that's the exact act.
which is really an amendment of the Public Act 200 of 1945.
Okay.
What you were just speaking about.
Right?
When you were speaking, you mentioned a couple things. One was these links that are together. Would you say that you're talking about the unbroken chain of title?
Well, in the example I was looking at is assuming we had a perfect link or perfect chain, that they all worked. But I also contrasted it with the situation that sometimes we'll have in 1923, somebody vanishes and somebody starts paying the taxes and takes over and then quiets title.
Because the Public Act 200 of 1945, they called it the 3-year look-back or grace period, which meant that between 1945 and February 1st of 1948, you were allowed to go back and renew whatever interest you had. That gave you a shot at renewing it.
That's actually the second amendment to that Public Act.
Okay.
Because originally it was a very short window. And that was a delay of
But
basically
they did it
the
for
3-year window.
constitutional reasons. And so the law, as I've been told and have read it and understand it, is that if you didn't renew those rights by the 3-year window, they became extinguished. And at the end of 1948, then if you did renew it during that 3-year period, then you had 40 years in which you had to renew them again.
That's incorrect. The Act said you needed a 40-year period of which there was no reference. So in 1948, you had a 39-plus year exposure that if it was referenced, it still fit within it. But you needed, the 40-year concept is still there.
Okay, and this is where we're gonna disagree, because I have other opinions on this that are, reputable as well. And I think this is one reason why I think we're here today, and this is a good turnout, is that there's a lot of people here interested in finding out, not necessarily the law, but how someone could come in and claim mineral rights, not to state land, because that's understood, but to private property. And there's, certainly a difference of opinion. Certainly the Mark Nordine lawsuit that came up, I'd be interested in, finding out more about. But I also think that there's a lot of people here would disagree, that the law actually said you have a 3-year period, and the Public Act in 1997 gave another 3-year period of time. There's an Attorney General's opinion, I think it's
Familiar with it?
Okay, 7154 that addresses this, and it also spells it out.
The Attorney General's opinion has two issues that's not addressed, is delivery and acceptance, because I'm going to talk about why there are some problems with the legislation that was passed in 1997. It also has a 3-year window, you are correct. I'm trying to contrast the legislative, how they've changed the term of minerals, and how they have modified it from its general form that's out there. Now, I'll give you an example. Anybody familiar with Iron Mountain in US 2? You know where the Chapin Pit is? Where the highway literally goes through the subsidence area on both sides that collapsed in the late 1930s? The Chapin Pit property surrounding it was conveyed to the city of Iron Mountain in the late 50s, early 60s. In the mid-1980s, a gentleman fell in the pit and drowned. And he sued, and the issue was, where was the liability? And in that particular case, the liability went to the mineral estate holder. So in our example, if you're having, anytime you have a deed, for instance, I own the former township dump for Lake Township, if there is such a thing. What we've done in the past to various portions of our property, we probably wouldn't do today, but it's there. Tom and I don't like one another, and that's not true, but in my example, we're using it, because you're my volunteer this evening, and I decide I don't want to pay the taxes anymore, and I go down to the Register of Deeds, and it says a deed that says to Tom, and it uses the legal description of our former landfill, or dump we'll call it, because it was before we used landfills. And it's recorded. Who owns that property? Tom doesn't know about it. Who owns that property?
Township?
No, I owned it before. I recorded a deed to Tom, but Tom doesn't know about that deed. Because, of course, on the deed, I put his address as General Delivery, St. Louis, Missouri. Who owns that property?
You still do.
Why?
You own it.
No, this is not a mineral issue. We're just doing a general
Never accepted.
Pardon?
He never accepted.
That is the correct answer. He never accepted. There was no delivery and acceptance. Because normally when you record a deed at the Register of Deeds, whether it's mineral or not, the law presumes the act of recording means the person named in the document accepts and has taken delivery of it. If Tom doesn't know about it, he's not the owner. You need to keep that concept straight, because the Michigan Marketable Record Title Act says to the city of Iron Mountain now, you own it, because there's no notice within the 40-year or within the 20-year period. So the city of Iron Mountain, doing nothing, never accepting delivery, never having any knowledge of it, now has been given a liability situation. You think that's what the law should do?
In your example, was it recorded?
The deed was, yes. But see, the mineral interest in that example was to a company that subsequently did not record its claim under the statute. So under our current 1997 change of the Michigan Marketable Record Title Act, the City of Iron Mountain, if you treat acceptance and delivery as not required, just inherited the liability. Do you think you would want to do that? Do you think Tom would want to take that dump that I gave him?
Yeah, first off, we're talking about a piece of property that already had the minerals taken out, and it's liability, and again, I'm no lawyer, but I would assume that, liability has a different standard. And, we're talking about undeveloped property to where there's a passive, where somebody has the responsibility to claim under Public Act 200 of 1945, by language, they have to renew their rights. Rather than give them away, they have to renew them. Now, that doesn't mean that they're giving away liability.
Sure it does.
Well,
Follows the estate. There might be environmental liability going backwards, but the liability for the actions go with the mineral estate.
The act also says unless it's obvious that there's some impediment to the property, meaning that an easement that has a road on it doesn't...
Totally different issue.
Well,
That's a visible sign that's out there. That is the 1960s amendment to the act. And if you want to look at the litigation right now, you go to an unpublished case in the Michigan Court of Appeals called Johnson versus GWHC Club that talks about the Michigan Record Marketable Title Act and how some of those issues get dealt with. The problem, and I'm pointing this out because I want people to understand this, is delivery and acceptance is still part of the process. And if you think that the failure of somebody to do that automatically means you get dumped with the liability, you need to look at that issue. And I'm pointing this out because a lot of times I see people that come in and say, the family farm was right next to this, we bought this property, and now the mining inspector is showing up saying, hey, this test pit is collapsing or whatever. And see, you can add to that. Everybody thinks we know what has been done in the past. You will be shocked to realize what we have done in various areas. And so I'm pointing this out. And the Attorney General's opinion interpreting the 1997 amendments that Tassanovich and Smith put together doesn't talk about delivery and acceptance. And the Attorney General doesn't talk about it because he doesn't have an answer to the issue of the liability. And that's the case that will come up in our courts, and our courts will have to look at delivery and acceptance. They're going to have to do it, because there's no way in the world it's fair for me to give Tom the old dump, him not to know about it, if it's a surface estate, but it doesn't apply to the mineral estate. It's all interests in real property. Remember the 1997 amendments to that act says except for these minerals that they define, or that they exclude, all other things go to the 40-year period. Now I want to talk about this 40-year because I've had people come and I've spoken before and talk and to get all excited that if they don't do something, their position is impaired. First of all, anybody who records a document at the Register of Deeds needs to know what they're doing. If you blow it and you record it, there is slander of title under the statute or a common law that you have a risk. And this is happening over and over. The second factor is, about 8 or 9 years ago, we had a problem where if I was in court and the judge ruled against me and I was a litigant and I wasn't happy, I go down to the Register of Deeds and says, Judge Payant owes Steve Tinti $4 million and recorded at the Register of Deeds. And the next week I say, well, it's really $4,500,000 because of interest. And Judge Payant, who's now deceased, goes and says, I want a mortgage because I want to improve and update. And it shows up on his title report, he's got a problem. So our legislature passed an act that says when you record a document making a claim in real estate, you have to have, as part of it, to perfect it, proof that you have served whomever you're trying to displace. That's what the law says. So you need to be very, very careful at the Register of Deeds. A lot of people ask me questions like, Steve, can I do my own deed? And my standard answer is, if you know what you're doing and you want to do the document, you can do it. But please understand, if you create a problem, you've created the problem and you're responsible for it. So what I always tell people is, gee, if the legislature says slander of title, and let's talk a little bit about slander of title by statute, which is in the Revised Judicature Act, you get the other side and you potentially get actual attorney fees. Never want to be in that position, because then you end up paying your side and their side if and when you lose. Secondly, there's a presumption of damages, and that's why you always like the legislative slander of title over the common law, where you don't get attorney's fees. Now, I want to step back a moment, because the way you really do it is like Tom and I were talking. You start from patent and you go in each single link. Please understand, the Marketable Record Title Act does not limit your search to the Register of Deeds office. It says public records. It does not define it. There is not a piece of litigation that has defined it. There is an adverse possession case involving hydroelectric flowage rights that they felt that the records at the treasurer's office also apply. Well, what about the clerk's office? What about, where do we stop? Does it mean we just stop in the county? They haven't defined it. If you read the definitions of the Marketable Record Title Act, you get very, very worried about these issues. In the case that I told you, the Johnson versus GWHC, which is an unpublished Court of Appeals decision, and in all fairness, I'm one of the attorneys in the case, so I'm plugging my own case. It talks about the Marketable Record Title Act, and it talks about something you'd never look at. And just to understand what you need, I'm going to pick on Tom Quigley. Tom Quigley owns 440s of property. 2 along the road and 2 in back of the road. Okay? Tom Quigley's grandfather split off and gave the front 240s to Tom and gave the back 240s to my wife sitting in the corner back there, Debbie. Okay? Tom doesn't like Debbie. From day one, they just never got along. Tom says you can't go across my property to get to your back 40s because I've got you trapped and you're going to sell them to me for 10 cents on the dollar. Okay? The Michigan Marketable Record Title Act, there's no road there. There's no document at the Register of Deeds office that says there was ever an easement granted. So there's nothing visible and there's nothing there. Does the Marketable Record Title Act cut off what are called implied easements? The court says no, because they arise by operation of law when Tom's grandfather split that property. And that's what Johnson versus GWHC talks about. So you need to understand that what at first blush when you read the Marketable Record Title Act, there are nuances in terms that are not defined that are very problematic. And that they refer to that legislation as curative. Quite frankly, it potentially can become a minefield. Tom, you take the position on the Marketable Record Title Act that if you don't record it, it's over? That's a fair statement?
Yes.
Okay. So if that's what the law says, why do you have to record something at the Register of Deeds?
Chain of title,
Why would you record something at the Register of Deeds?
so that all people who would be involved in that property know.
Okay. Would you do your homework?
Absolutely.
Would you check every link?
Yes, I would.
Would you rely on the advice of a professional?
Yes, I would.
Tom has just done a very good job on analyzing the issue. That is not what is happening with people out there. I can tell you about a month ago we had a forum in Iron County that was put on in Iron River where there was discussion about potential mineral activities and there was a general discussion about the Marketable Record Title Act. And I've had a half dozen people come to me totally confused given a pre-printed form that says, fill this out and bring it down to the Register of Deeds and record it. And I can tell you that is a nightmare if you haven't done your homework. Now, I sit back and say, maybe I want the best of all worlds. I don't know if any activities occurred there. If the Marketable Record Title Act says I don't have to report anything, and the act of recording exposes me, if I do it wrong, to slander of title, potential damages, and I have to prove I have served an entity that we can't find anymore. In 1921, Jas B. Goodman didn't make any reference to the minerals that it reserved in all of these deeds. And the Marketable Record Title Act says it's gone. How do we prove service on Jas B. Goodman? They're a defunct corporation of the state of Wisconsin. They're gone. There's a lot to properly do that, and that's not something that somebody handing out a form says, this is what we do. Now, Tom, in his example of saying, please prove it to me, has done a very wise thing. He has said as landowner, if you're claiming you own something on my property, show it to me. Show me how it works. Anybody worth his or her salt should be willing to do that. Tom would probably rely on some professionals and take a look, and there can be disagreements. I don't have any doubt with it. I can tell you that having litigated the Michigan Marketable Record Title Act, I can tell you that first of all, there's very few attorneys that really understand it. Secondly, there's very few judges that understand it, because most of our judges, and this is not a slam on judges, most of our judges don't come from the real estate segment of the law. They come from the criminal defense or the prosecutor's office. They don't sit and deal with these estates. They can't tell you what happened in 1066. They can't tell you all of these things. They can't tell you about what's the preamble of the Northwest Ordinance when it deals with riparian rights. They don't, because that's a specialty that you need to look at. So what I'm trying to do is to tell people that if something is worth doing, it needs to be done well. And we are giving a lot of misinformation and poor advice if we start handing out forms that say, fill this in and go down to the Register of Deeds office and record it. Could work. But if they go and fill it in and it's a problem, who are they going to look at to bail them out? Nobody. They walk down there with their $15 or $16 check, and I have to say this in all sincerity, the Register of Deeds in most counties will record the menu from the local restaurant if you give the right fee. So I want you to know that there's no analysis that goes on. There's none of these things that go on. So,
Well, if I could again, I don't want to monopolize this, but this is, I've spent a little bit of time on this. Is the, I think you're, directing us at some people here. First, I absolutely agree. People should go do a title search. They should employ a title company. Whenever possible, instead of having an attorney write an abstract, they should actually buy title insurance.
title insurance gives you no coverage on the issue.
It does if it's not an exclusion.
Most of the jackets of title insurance exclude mineral coverage.
Well, again, I've
Right.
purchased property recently and I made them take that out.
Okay, but you exercised a judgment that is normally not done. Can you buy coverage? In certain counties you can.
Yes.
In certain counties you can't. The average person would not know how to do that.
Well, let me go back to the reason why I'm bringing this point up, is that the penalties really, and I think you might have even argued this, is that if you're not aware of slander of title and you become aware of it, there is no penalties really after 1 year, because the slander of title statute lasts 1 year. So if people do...
Not as to real property. Real property slander of title is going to be either the 10-year or the 15-year statute.
Okay, again, I'm going back to a
Right.
lawsuit that I read that used the argument that slander of title was 1 year statute of limitation. And I'm not sure if you wrote that or if, you know, somebody did, but that's what I read regarding property, where we're talking about by persons that, you know, that are here.
I can tell you though, the statute for real property is longer.
Okay.
Slander of title can include more than real estate.
Then the next step would be the actual, when you look at a piece of property and you go back, you know, again, I want to go back to that unbroken chain of title, is that if somebody doesn't record a deed, or doesn't record they're interested in that, and then someone at a later date picks up that claim, you know, there is a broken, and the Marketable Title Act says you have to have an unbroken chain of title. Do you agree with that, or?
Remember in several of the fact equations, I had conveyances that said subject to all easements, reservation, mineral and mining rights. So I mean, you need to analyze each link. And that's the component that I think is very critical. Because, for instance, a standard deed that I will draft will have language similar to the following. Because if you understand the title insurance industry and read the fine print of title insurance coverage, you will come to a conclusion that what you're really covered for, unless you've done a lot of work, is very little. It will say, subject to all matters of record. If I'm representing a client, and what they are doing is saying, whatever's at the Register of Deeds you take subject to, and there's a reference to a title reservation for mineral rights, that is going to revive it. You know, you need to do the analysis. And you need to do the analysis, and Tom brought out the point before, that he has done more than what most people do. And the point that I'm trying to make, and it's a very simple point, is number one, you need to know what you're doing. Number two, anything that's worth being done has to be done well. And number three, there are risks when you record items at the Register of Deeds. I have a gentleman right now that recorded actions against a judge in a court in the last 4 years. He currently has a bench warrant and criminal charges against him. And he is not in the state of Michigan any longer. It happens. I guess I point out, you know, everybody assumes nothing happens. When you sign that affidavit that says, I claim, you don't have a defense saying, I think I claim. It says, I claim. You can't have it one part way, you got to go all the way. And remember, you know, there's other components to it. So I mean, in my example, and I think Tom brings out a very good point, my example is, you need to do it right if you're going to walk down it. And you need to understand the risks that are there. And quite frankly, as Tom indicated his example was to Paul, did I get it right? Okay, I did get it right. To Paul, because Tom says, Paul, prove it. And Paul's going to come in because Paul's a very, crosses the I's, crosses the T's and dots the I's. He does his homework and said, link, 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 link. Tom says, I don't like that. Tom does the analysis that Tom would do, and at the end of the stage, they still disagree. There's a forum to solve those things. Circuit court deals with these all the time. But at least what you're doing is you're looking at people who have done their homework well. And that's what you need to do. And how do I tell the lady who walks in my office that says, here's the form, sign it and record it, and you're all okay? What type of service have we done in dealing with it? Better, the example is even better. She was in a historical mining area. There potentially was liability. You think somebody would have chatted with that and said, why in the world would you accept and take delivery of that when you know there's a risk? Now she might do the homework and say, I've done my homework. I've looked at the mining records, the mining inspector, we've looked at it, I'm comfortable that there's no liability. If she's really cautious, she hired an engineering firm and they came out and did phase 1, phase 2. If she's really suspicious, If there were a problem, she might even look at a baseline environmental audit to avoid the historical liability. Those are all things that people are not talking about. I mean, I'm not trying to dissuade people from doing things. I'm saying, let's do it correctly. Yes?
Another one. Under the MRTA, which is the Marketable Title Act, there's another danger, and one reason I think why people are compelled to go file a notice of interest on their property is that you could create a new chain of title. If a person is unaware, and somebody claims title to minerals, say, on their land, 20 years later, they have created a new chain of title and actually would have a legal standing on a piece of property. So, you know, the old adage is that...
It's a good attempt. The failure of that is going to be is the property is going to be in the physical possession of another party. And the Marketable Record Title Act has a component in the statute that says when the property is in the physical possession of somebody else, the act doesn't trigger. So if I'm the surface estate holder and I'm sitting there, that's not going to work because that exception to the act applies.
But aren't the
Yes.
mineral rights reference though is only for severed minerals anyway, so if you were making a claim for severed minerals, obviously
but
there's
hang
gonna
on.
be another person.
Tom's logic is, if the time period is ran, I own him as the surface estate. That's his position. As soon as he takes that, he is in the lawful possession of the mineral estate. If the issue go up, and we can do it. Yes, ma'am.
I have a question, and not being a lawyer, I'm hoping,
Count your blessings.
I'm asking you, I'm asking you possibly for a yes or no.
Okay, that's even harder with an attorney.
Well, please, because then my second part of my question I'd like to direct to Mr. Quigley, if possible. So I'd like to have just 30 seconds or so here of the time. Several years ago at our Lake Township Board meeting, Mr. Quigley had some lawyers from up in the, they might have been more up from Crystal Falls, I'm not sure, but from that mining area.
That's me.
Oh, okay. And I clearly remember at that you addressed the board, and the people that were there, I was there, that, well, that's you, that's my answer, yes, because they threatened our township with a lawsuit and gave instances where different units of government had attempted to stop such a movement as this and were being sued and were going to go bankrupt. So you answered my question. You were one of those people. That's what I thought. I thought I recognized you.
I agree, I'm the attorney.
Okay.
Okay, I don't have any problem with that.
And then, Mr. Quigley, and this, based on what Mr. Tinti has just said, I think based on what he has just said, if these claims of interest or showing an interest in your property's mineral rights or in your property are of no value, or worse yet, slanderous or illegal, how did VMS, Back 40, Aquila, MPC, or all the different names that you had, get the mineral rights on private land, or were they just given to you or sold at a bargain to you by the state? And what did that cost? How did you acquire those mineral rights? Now, that's a question for Mr. Quigley, please. No eye contact between the lawyer and the...
He is better.
Public comment.
That was a pretty broad question, but
Well, how did you
all the
get those?
mineral rights that we control, we've either leased or purchased from the owners.
Okay. So what did you file at the courthouse to get those?
We've, well, we didn't get them, we
Bought.
leased them
Yes, okay.
in a private contract with the owner.
And then did you file something then to make sure that those were...
In some cases we have, we're not required to.
How did the owner know he had them?
Well, that's this chain of title that we're talking about. And we would never lease or purchase a mineral interest unless we did our homework and we're very convinced there was a good chain of title linking the person we're dealing with to the mineral rights.
Then there has been some
That's
reference...
and I think Steve was trying to address that.
Yes, I realize.
The claims that people can go in and just take mineral rights is just not the case.
You
It
just
just
filed
can't
an
happen.
interest in your property. Okay, so that's how you did it. And so that's wonderful. I'm glad you did it that way. My next question is, and it has been referred to, I'm not sure by whom, about a lawsuit, and I mean, we just hear bits and pieces, and where somebody did sue to get their mineral rights back because of the manner in which they were acquired. And it is our understanding, and perhaps we're wrong, you know, how the rumor, my mother used to call it street talk, so be careful, that they were given mineral rights back and possibly even a financial settlement. Then if that may not be true, see, but if that was the case, then if those mineral rights were just handed back, does that say something about the manner in which they were acquired, Mr. Quigley, or not? And you-
No,
No, okay,
I
yes
think-
or no?
Let me do a little bit of talking,
Okay,
because
that's fine.
a
I'm
couple
done.
things we tied. Remember I talked about the tax reversion to the state of Michigan? Every year, sometimes twice a year, there will be little notices published in the paper as to leasing of the state rights. Please understand, the state does not sell the minerals, they lease whatever they own. Please understand the definition of minerals prior to 1964 is a little different than normal. I want to put that out there because that's an issue. So I can tell you a component is from state leases. I can tell you that the exact process that I talked about of starting with patent, doing links, analyzing out, was done and ultimately resulted in many instances of acquisition. And it was a piece of property. And private parties do not have the ability to take private property. We don't have eminent domain. So we negotiate. In my example with Paul, I said to Paul, I want to buy your minerals. I'm satisfied with the equation. And Paul's a sharp guy, and he says, what do you have there? What can we do? I want to make sure I'm not underselling or overselling. And different type of arrangements can be made. That's a private transaction, which involves the payment of compensation and things that go on. And that's how you acquire such rights. Now, there are instances, and I have seen them in my practice, not necessarily in Menominee County, where the undivided mineral interest in 40 acres was 128,642 of an interest. That is what we got down to try to figure out the common ownership of a quarter property located in the city of Stambaugh, Michigan, that we had to quiet title. We literally had an abstract of 1,000 entries long that had all sorts of problems. And what we ended up doing is going to court and saying, we wish to quiet title, judge, here's the evidence, make a decision on this, and that is what a court did. And I can tell you that there are instances that that process is necessary. Just like probably all of you can tell stories of friends or family that somebody had to go to court and quiet title to the property because there's a problem out there in some of the property interest. In my family, my great-grandfather came from Belgium with two buddies. Two buddies went back in the 1920s, never showed up. My uncle came to build his house in the mid-1960s. The title examination said, wait a minute, you got these two guys, what do we do? They had to go to court to quiet the title to the property. And got an order that says, yes, my grandparents did own it, and yes, if they do a deed to uncle, he can build a house because the bank is satisfied with the title and they'll do it. So I mean, it's just examples of what we have that are out there. But I guess one of the things, and I don't want to go too long tonight, because I might get I can talk for hours on these topics, and a lot of you probably wouldn't like it. I guess the thing that I tell people, it's an important issue. It's an issue that we need to, when people are asking questions, remind them. Anything worth doing is worth doing well. And fundamentally, I haven't talked an issue of whether you're for something or against something. I'm trying to relay to people the risks and pitfalls what really needs to be done to do it well, and how you resolve conflicts if the need occurs. And we need to go forward with that type of approach. And we can talk about all of these, like the Marketable Record Title Act. I mean, you want a statute that'll bore you to death if you're really not interested, read it. It causes you more problems on issues than you can imagine. But it was the legislature's attempt to fix it. Just like when they tried to solve the severed mineral interest in 1997, the lobbyists got in the way. Oil and gas, which follows a different body of law, which I have not talked about tonight and didn't want to get into because the law is different. Sand, gravel, limestone. I mean, what lobbyists do you think got into that one? I mean, that's ultimate, because when the statute was introduced by Tisanovich, I should say the House bill, it got rid of everything. And what happened is they chipped it away. So we made what could be a complicated topic even more complicated. Wouldn't it be nice, in the example, if in 1880, ABC Company reserved minerals, sand, gravel, stone, all of those nice things, and they vanished? I mean, I think the legislature's attempt was to solve that. Well, what they adopted in 1997 says the oil and the gas stays, which is a mineral by definition. The sand and gravel, which consumes the surface, stays. I mean, don't you think they should have maybe went another step? Don't you think there were some powerful lobby activities opposing that? I mean, really, if we wanted to clean the issue up, it should have been a full sweep. And I think had they done it in a proper fashion, that clean sweep could have worked. Unfortunately, that's not what we did. So hopefully, and I thank Tom and I thank Paul, I enjoy, if there are any questions afterward, I will stay around for a little bit. I know there's some people over here that are ready to field types of questions, and hopefully I've tried to bring some issues to the table that you need to appreciate to do it well. And my advice to everybody is do it right if you're going to do it. Do your homework, because if you're putting the effort and the time and energy, you want to have a result. And that's where you go. Thank you.
If I understood right, it sounds like 11 mineralized are probably reverted back to the state.
In some areas, it's pretty significant, yes.
Right, and there ever a time that the state reverts them back to the landline automatically?
Funny you should say that, because in 1964, they changed the policy on what they would reserve. And they just did it as a result of a statute. Recently, I've been seeing deeds come through on state sale property that affirmatively say, for instance, you go to these land auctions, there'll be a little publication that says, we're having tax reverted lands, you can show up and you can bid. There's now language in those deeds that say you can't sever the minerals or the property reverts back to the state. So the state of Michigan slowly is trying to say, let's bring these things together. And in effect, in some respects, they're trying to undo the Norman Conquest of 1066. But that's what is going on. And I think it's positive in some respect because most of the state of Michigan does not have a severed mineral issue. And unfortunately, people understand the topic poorly. But when you really look at it, I think the modern trend is to try to reunite them because there's all sorts of unique statutes out there on what percentage of people that own the minerals can be utilized in developing something. There's all sorts of interesting things out there. But I think the bigger issue that really is coming down, I've seen it in some of the permits that have been recently, or leases that have recently been issued that say, if you don't have the surface holders' consent, we won't let you develop. I mean, I've seen that in state leases, I've seen now in these deeds, so I think the direction is going to go to attempt to unify them. It's just unfortunately, the tools that we have been given are not perfect, and we need to do things well. Yes?
There was, in 1999, there was a statute passed that said when the state conveys, well, except under certain circumstances that it says it has to convey the minerals with the surface, and includes that clause that you cited. And there is, to answer his question, there is, in that statute also created the opportunity for individuals to apply to purchase minerals from back.
That is correct. That, I believe, is also available online on their website.
Correct.
That information, if I recall, it is out there. But please understand, if you look at that process, it's not simple. But the flip side is I deal with a lot of real property where the state is attempting to acquire by grant through like local units. Township applies for a grant that wants 80 acres to add on to their park, their rustic park or whatever. And they're imposing conditions like you must acquire mineral rights. There's all sorts of things that are going on there. And I can tell you that, for instance, the largest state acquisition of land that occurred in the Upper Peninsula was the tip of the Keweenaw Peninsula in the state of Michigan, and that was through the Nature Conservancy.
Do you know who he worked for?
No.
He works for the DNR.
Okay.
So I'm just saying
And we're in agreement.
Yeah, we are. I'm just saying, you really have two different issues. One is you're talking about acquisition through use of the Natural Resources Trust Fund, and then also there's other land transactions that people do all the time to acquire, trade, exchange state land. But then there's a third thing that I was referring to, which is separately applying to purchase minerals. But it's again at a fair market value. So
And
it's not
if I'm right, it's been a while since I read the website on that. Doesn't that get referred to the state geologist and some other things that go with it? There's some other wrinkles to that, but it's on their website.
Yeah.
And it's out there. I have not yet met somebody that has actually completed that process. Have you?
Do it all the time.
Okay. I just have not seen one of those that are out there. Yes.
Doesn't the state still consider sand and mineral?
Sand and gravel is considered minerals on state tax reverted lands prior to 1964. And if you read the Marketable Record Title Act amendments of 97, they define sand and gravel as not a mineral for purposes of the 20-year rule. So, it depends on what issue you're dealing with. But generally, sand and gravel in its pure form is not considered a mineral under general Michigan law.
You got a division there that I worked for. I had 37 years with the Michigan DNR. And mineral is now included. Forest management, fire, and mineral.
And I represented a man who started taking gravel out of his property in 1954. He got into a row with the town. You'll love this small town politics. Continued to take gravel. He had a little run-in. He was on the township board with the local DNR person, and all of a sudden, he gets notice saying they're citing him for taking gravel because it's tax-reverted land. And we go through an enforcement process. Ultimately, I think it went to the assistant director, I think it was Frank Apoka at the time, who's a man from Norway, if my memory is correct.
Yeah, Frank is from Norway.
And they resolved the matter for $100 because they didn't want to go to trial on whether or not an individual can adversely possess sand and gravel rights. But fundamentally, it happens like that. Most people don't ordinarily think of sand and gravel. And remember I said the Fisher versus Keweenaw land case in 1963 was very important because that case took Keweenaw land, which is a very large landholder and mineral holder, to task on the issue and said, it better be in your reservation that you have those rights.
Was this Fisher a construction company?
No, Fisher was an individual. I thought he was either from Bessemer, Michigan, but he took him on. Gogebic County, very good trial court opinion. The Supreme Court basically said, trial court, you did the analysis right. You look at the language, you look at the intent, the area was a hard rock mineral, that meant shafting and stoping as opposed to quarrying of the surface. And the idea of the surface estate still has rights when you have a severed mineral, and to consume the surface, you better have it in your language, otherwise you have a problem. Thank you, everybody.
Did you see this? You guys should have a